reflected in the way that the United Nations Security Council is organized, with 5 permanent countries, none of them African, and the way that this power is then exercised to intervene on our continent. And I'll come back to some of the interventions that are to do with the International Criminal Court. This imbalance you will also find in economic terms, that Africa's economic development has been hampered through all sorts of reasons, but including this issue of the flight or export of our resources through illicit means. More recently, you'll be following the leaks from Panama, and you'll know the staggering amounts of wealth that this continent is losing. So the context in which we talk about these questions of justice is a context of a diverse continent trying to work through the challenges of nation building, the context of a world where the power balance is tilted against Africa, and where by that I mean where we have to struggle to make our voices, our priorities heard. Now I want to come to the matter of the International Criminal Court. This court emerged in this context when, after the Cold War, when you had the collapse of the former Yugoslavia, you had the genocide in Rwanda, you had the conflict in Sierra Leone, and you'd had the situation in Cambodia, when the global community made interventions, justice interventions, and say that the crimes that are being committed in Yugoslavia should not go unpunished, and then set up a special tribunal to deal with that. An ad hoc tribunal is how that's referred to. And the same for Rwanda, the same for Sierra Leone. So it was felt that this ad hoc approach to addressing these questions of justice, these questions of dealing with the most serious crimes, should be better managed by having a permanent court that could respond whenever there was a need for justice in those situations, including situations of conflict and repression. So it was that in the summer of 1998, most of the nations of the world converged on Rome, the capital of Italy, to negotiate a statute for an international criminal court. They managed to agree on that statute. And these are some of the key pillars of that statute, and they're relevant for the discussion we're going to have on how this court has operated in Africa. The statute that was produced in 1998 reflected the principle that some crimes were now of concern not only to the societies where they were committed, but to the international community as a whole. So crimes against humanity, as suggested in the name, war crimes, certainly the crime of genocide. So the statute set up a court that would be able to deal with these crimes. It also adopted a particular principle, because as you can imagine, the idea that the right to try your own citizens would be handed over to an independent court and prosecutor is a difficult one for states, for all states. And as a consequence, in the statute, they made sure that there was a principle that this court would not act unless a state, which is a party to the statute, was unwilling or unable, genuinely, to exercise its criminal jurisdiction over those crimes. It's called the principle of complementarity, a rather long word, but it means that states have priority. So it has been called the court of last resort. It was not intended to be the court of first option. It was intended to intervene when there was a failure through inability or unwillingness. To ensure that it delivered justice without influence. It was decided that the prosecutor should be independent and shouldn't take decisions based on what states wanted specifically, but would initiate his own investigations, her own investigations, whenever a situation arose in a country that had signed up to the statute. But one of the provisions of the statute is also that the Security Council has the right to refer a case to this court, regardless of whether the situation arose in a country that was a member of that court or not. So as you can see, the court now locks back into the international system with the Security Council that is not representative. In fact, with the Security Council, where quite a few of its members, but 3 of the powerful members, are not signatories to the court, have not ratified the Rome Statute. So you have Russia, China, and the United States themselves not being members of that court, but able to make referrals to that court when they deem that is inappropriate. Now, as you'll recall, that this court started its work in 2002. It had to wait from 1998 because it needed to secure the relevant ratifications. To this day, 34 African countries have ratified the Rome Statute. South Africa apparently being the first one, and also being the first country to domesticate the statute of that court, as you've been hearing in the litigation in your national law. I don't know how much enthusiasm there remains for the project, but you were the first ones to go back then. Now, then the action began. You now had a prosecutor who started to make sure that he had something to do. And I'll pause here and tell you my first experience with the court. As President Mbeki introduced me, he said I was from Uganda. In 1999, I went to northern Uganda where there had been a long conflict between the Lord's Resistance Army and the government of Uganda. We called it a proxy war between Uganda and Sudan because they disagreed about the situation in South Sudan. So they were, in the language, supporting each other's insurgents. I went there to carry out some research on a rather dry topic, and it was access to justice in conflict areas. So I was meant to look into whether courts were working, and if they were not working, what did people do to resolve disputes and to deal with crimes? The area was still in a state of war at the time, and most of the population had been settled, forcibly in some cases, in camps, internally displaced persons camps, essentially internal refugee settlements. If you went to those camps, they were some of the bleakest places where anybody could live. I remember going to one of the camps, which had about 30,000 people living in a very, very small area. They hadn't had a chance to build decent housing. They had little huts, what in southern Sudan and Sudan they call tukuls, thatched huts with mud and wattle bricks for walls. I spent the time asking them about law, asking them about courts. They were always very polite. They helped me a lot. After I finished with my questions, they invariably said, but we want to talk to you about something else. And what they wanted to talk about was the government of Uganda's resistance to the idea that members of the Lord's Resistance Army should be amnestied and returned to Uganda in order to resolve the conflict. It's the first place that I had a conversation about the tensions between peace and justice. It predated the ratification of the Rome Statute. So the idea that this is a new debate in Africa is simply not correct. It's an old debate, because the question of justice, the question of peace, has always been a priority in African context. It's been revealed more strongly in some countries than in others, but the idea that those who commit serious violations of the rights of African people should be made accountable has always been part of the way that we approach conflict. And coming from Uganda, I can say that is true for the dictatorship of Idi Amin, that is true for the mismanagement of the country that followed that era. I'll go back to this camp where I was having discussions about questions of justice. When I left the camp, that particular camp that day, I traveled back with a human rights, a very senior human rights lawyer. She's not a lawyer, she's a historian. She'd been on a commission of inquiry in Uganda into the violation of human rights. And she had come to this camp with a film crew to see what was going on and to record it. As we were sharing our stories, she said to me, "Did you notice that there were no flowers in that camp?" I knew something was wrong with what I was saying, but I hadn't made the link that there were no flowers. And the point she was making was that this community had completely lost hope. They couldn't even plant flowers. Now, I'm telling you this story in order to reflect on the impact of conflict on communities. Not only were there no flowers, but the death rate of children under 5 in that part of the country was the highest in the entire country. And so the members of that community in northern Uganda started to advocate with the government to say, please reach a peaceful settlement of this conflict, because the price that we're paying for your insistence on prosecutions is too high and should not be paid by us in this way. In fact, they started to say that the government's policy amounted to a genocide of their people, because it could not win the war, but it was insisting that there was no room for sorting out the conflict peacefully, and there was no room for making concessions on the question of accountability. Now, this dilemma, which was being played out writ large, came to haunt the International Criminal Court when the president of Uganda referred the situation in northern Uganda to the ICC. And I'll come to the criticisms that they faced in Uganda. But first, to go back to say, just to recap, the formation of the ICC, the ratification by 60 countries, and the establishment of new cases. Now, the supporters of the court will point out in Uganda and elsewhere that Africans are actually the biggest bloc under the Rome Statute. That 34 of the signatories are African countries, and they signed up willingly. They also point out that most of the cases that came to Africa, that came to Uganda, were on the invitation of the governments of Uganda. They argue that the involvement of the court has given greater visibility to the continent, has shed a spotlight on conflict in a way that might not have been possible but for the intervention of the court. And that the prosecution of key leaders concentrates minds and is a deterrence to others who might be tempted to abuse their power. So, according to this view, in general, the existence of the court has forced the question of justice up the agenda when it otherwise might not have been a priority. But as we know, there's been resistance to the ICC. And part of the reason for this, as we know, is that until very recently, when the situation in Georgia was added to the list of matters to be investigated, all of the cases of the court were African. And most of those cases arose in situations of ongoing conflict. And the African Union's resistance to this was because these interventions complicated the search for political and just solutions to these conflicts. It is worth noting, in fact, that the African Union did not make any policy statements until there was an indictment of a sitting head of state. Now, the reason for that was that by going for the leadership of a country in a situation of conflict, in a situation where there were efforts being made to resolve peacefully a long-standing conflict, the introduction of justice risked jeopardizing that search for peace and stability. It meant, in its judgment, the African Union that is, that some other types of indictments might not go to the heart of the risk to peace. But by indicting a head of state, this was deemed to be a particularly dangerous move, especially in that delicate situation that obtained in Sudan at the time. The critics of the court say that the case in Sudan and later in Libya were referrals by the Security Council. They were referrals of countries which had not themselves signed up to the jurisdiction of the court. They were referrals by a Security Council whose members themselves were not parties to the Rome Statute. And so the Security Council had acted politically, particularly in the case of Libya, where after it had determined that there should be an intervention, blessed the NATO intervention, the Security Council had then supported a justice intervention. Now, the second element of the criticism of the court is that the powerful countries influence the decisions of the court. They don't do this directly, but it is said that the court will take into account the political needs of the countries, which are the third charge is to do with the management of the cases in the court. And here it is said that the court has mismanaged the you very much. Apologies. I'll go back to the third charge. Thank you, Max. One of the issues that the critics within the African Union and beyond have said is that the court has been badly managed. I have to say that is particularly in the dispensation before the current prosecutor. I'd say that powerful states influenced the court to take cases that supported prosecutions of individuals who were, I should say, ready and susceptible, countries and individuals who were susceptible to prosecution and to being targeted by the questions of justice and prosecutions. These allegations cannot be proven, particularly because it is said that these decisions were aligned in a manner that enabled the court to take decisions and reach judgments about what to do in a situation of conflict without jeopardizing the search for peace. It's important to address the question of justice and
Wait, if I stand with you, can you finish?
No, let him sit. Let him sit. Let him sit. Let him sit. No. Take a seat. Yeah, I'll come. I'll bring you. Take a seat. Take a seat. Thank you very much. No great nation is made of great government. It is great persons from various nations that make great nations. When President Mbeki was introducing Judge Afako, it was quite clear that there's a number of jurisdictions in the world that Judge Afako has been working on. When he arrived in South Africa yesterday, he was coming from the mediation on the conflict in Yemen. it is quite clear that a number of tasks that Judge Afako has undertaken worldwide, being that great scholar and a great jurist from this continent that is recognized all over the world, that has taken its toll on his body. But true like a soldier, he came and collapsed with his boots on. This is this level of commitment to humanity. This is this level of commitment to justice. This is this level of commitment to service to one another that this continent requires of many of us. And I dare say Judge Afako is a reflection of that. Because all of you have been here, don't worry. We shall continue with our program, and we'll continue with this program having to deal with the difficult questions. And those questions is whether in the agents of the cruel master, when there are no longer bullets or ropes, that the World Bank and the IMF are used as the agents of cruel master, is the question whether the ICC has been added to this duet, or whether the question is Africans are keen on promoting impunity and do not want to subject themselves for accountability, or rather, as Judge Afako was saying, context is everything. Without wasting your time, I'm going to call Professor Lawrence Juma, who's going to take over from me to facilitate this part of our discussion. Professor Lawrence Juma has lectured at Lesotho, at Forte, but now he's in Grahamstown. My difficulty with people from Grahamstown, Professor Pityana, is that there are no watches in Grahamstown. But you will recall there's a church bell that rings, calls for prayer at 3, another one at 4, another one at 5. This is how they conduct themselves. So there are no church bells here, Professor Juma. But we have an hour or so to proceed. The only person that has not been introduced on stage is Otilia Maunganite. I'm not sure, Otilia, what is this story about avid human rights lawyer? Human rights lawyer is a human rights lawyer. There's nothing, I mean, I hear the professors competing when somebody has become a real professor. They say, no, this one is emeritus. So that means he's different from other professors. This is just a human rights lawyer. But Otilia is a senior researcher at the security studies, focusing primarily on the work of International Criminal Court. She holds a Master's of Law in Fundamental Rights Litigation and International Human Rights, a postgraduate diploma in International Studies relating to peacekeeping and diplomacy, and a Bachelor of Laws with Sociology. She's currently a student at this university, Professor Makanya, and she doesn't have to receive any credit by being here because she's still busy with her PhD in the Department of Public and Constitutional Law. Professor Juma, come on stage and take over from me. Thank you very much.
Thanks, Max. Thanks for that very wonderful introduction. Ladies and gentlemen, I think it would only be fair if I did highlight a few things that Judge Afako was going to talk about. Because his speech is all written, I think it would be important just to highlight a few things that he was going to say. Now, he was going to talk about the role of the African Union And in his words, he says, I've often heard criticisms of the African Union that it fails to take into account issues of justice and peace. Now, the reality is that African Union is not the organization of African Union. Africans, without the ICC intervention, took seriously the need to abandon non-interference for non-indifference. Even before the Rome Statute came into being, the African Union adopted the principle that the Union had the right to intervene in member states when international crimes are being committed. And those of us who are familiar with the Constitutive Act of the African Union know that Article 4 allows the Union to collectively intervene when international crimes are being committed. Now, on the issue of African alternatives, thank you. On the issue of African alternatives to the ICC, the key task that all of us have who wish to see an African alternative which is true to Africans and which upholds the dignity of people is to do some serious reflection and adopt some responses and principles that will allow us to address the past in a credible manner that does not ignore it, but which does not prejudice the possibility of restoring stability. What is the content of such alternative? I should say that this will not be uniquely African content, although there are some elements which we find particular resonance from our culture. Now, in the first place, he says, context is everything. We should reach a better understanding of each of the contexts in which violations take place. Then he talks about the idea of reconciliation. What kind of justice is appropriate in addressing politically motivated violations? In the discourse about the past, I repeatedly came across the concept of reconciliation. If you attempt to use this word in some cultures, it sometimes induces panic or at least embarrassment. But I've reached the view that the idea of reconciliation runs very deep in many African societies. On the question of retribution, one of the reasons that criminal justice has become a greater obstacle is its emphasis on punishment. We have to recognize that in the context of political conflicts, indictments and punishments can easily be a way of taking sides in an argument and is often resisted because it hands political victory to one side. This is accentuated because international justice goes for the top, not because they pulled the trigger, but because they were at the apex of the organization within which crime were committed. The link between the person in authority and criminal responsibility is very short indeed. Now, instead, there is a need to adopt a contextual and holistic approach to justice, which takes seriously the political context and gives priority to recovery and healing relations within society and goes beyond symbolic retribution. Now, he says that in relation to the ICC, it is important to revisit the statute and to begin to insist as Africans that this must become the court of last resort indeed. This means that on the continent, whenever crime takes place, we must be ready to respond in a coherent way to how we propose to address those crimes. The task is urgent. In Africa, we are facing the challenges of violent extremism in Boko Haram and Al-Shabaab. Do we really think that the actions of Al-Qaeda in Maghreb will die down because we indict their leaders? This is not a criticism of international criminal law. It is an acknowledgement of its limitations. I think we, the African people, are right to ask the lawyers and the judges to acknowledge the limitation of our trade. The more one reflects on what changes are required to transform international justice, the more it becomes clear that this is a leadership question. We have a vacuum of leadership on this issue on the continent. And yes, the African Union has responded, often sharply, to the decisions of the ICC prosecutor and the judges, but this has been reactive. The debate has become more like a television drama series of where will President Bashir visit next. This might have distracted us. I was listening to your judges and lawyers debating the issues, and I wished that we had been debating the broader questions of how we bring about transformation from conflict in a principled manner. I believe that part of the reason that we have not seen strong leadership emerging is that we have tended to step back because these are legal issues for judges and lawyers. If we conclude that the question of who determines the form and content of justice at international level and who decides how our society should become violent and who decides how a society should overcome a violent situation is intensely political, then you have to recognize that you cannot leave these matters to judges and lawyers alone. I suggest three main arenas. Analysis, which includes the academia, think tanks like the Thabo Mbeki Foundation should develop thinking on these issues and mobilize Africans and those who support the aspirations of this continent to strike the right balance between the pursuit of peace and justice. Mobilization of opinion so that we can win the media battle, focus on judges and lawyers, which requires that international law is meant to reflect the values of the global community and to be informed by the general principles. Let us civilize international criminal law by infusing it with restorative principles derived from African cultures. And what do we take away from here? We must return to the key question of how to address the challenges that Africa faces and how we are to determine the proper place of justice in that process. We need to do this systematically, drawing on African principles and priorities. We should be tenacious in our insistence that Africans will shape the direction of justice and peace in the continent. Ladies and gentlemen, that was not me speaking. That was Jaja Fako speaking. Now, we've come to that session that I know most of you are waiting for, where we can ventilate ideas and challenge the panelists. But before we do that, panelists, I want to suggest that we kick off the discussion by asking you to say a few words, asking the president to say a few words, but basically to answer the question, should Africans withdraw from the ICC yesterday? Should we cut links with this ICC? Not even today, yesterday. And may I suggest that you only use a maximum of 5 minutes, because this group want to ask you questions. So you use a maximum of 5 minutes, you address that simple question, and after they have addressed that question, then I'll invite the audience to ask them questions. So maybe I start with Ottilia, because the audience have not heard your voice. Thank you.
Thank you very much, Professor Lawrence Juma, for the introduction, and obviously with great thanks to the Thabo Mbeki Foundation, as well as the University of South Africa for hosting this event and for welcoming me here. Before I answer your question, and yes, I'll remain within 5 minutes, I am going to really focus more on the notion of Africa's quest for justice, and then at the end answer whether or not African countries should remain within the ICC system. This will be the only time that I mention the International Criminal Court. I will kick off by actually speaking to what needs to be done in terms of responding to international crimes on the African continent. We can speak about what institutions those need to be, but there are still pertinent questions that Judge Bonnie Ofako started with, which is that on the African continent, we do need to be addressing the need for peace, as well as the need for justice and the need for security. Ultimately, if we're able to achieve those things, a lot of what we're yearning for on the African continent, to be able to achieve prosperity, development, for me to feel safe when I leave this room, it requires that the environment in which I exist is peaceful. And I'm speaking about myself as an African citizen, and yes, President Mbeki, I am an African as you are. And when we speak about what Africa needs to do, I'm not speaking about what African leaders need to do. I'm speaking about what needs to be done for African citizens like myself, who aren't leaders. And in that, I am reminded of the fact that near the start of this year, the trial against the former president of Chad, Hissène Habré, was concluded. On the 30th of May, this following Monday, the extraordinary chambers in Senegal will deliver their judgment as to whether or not Hissène Habré was complicit in the torture, the murder, and the maiming of citizens in his country. Those two were African. The reason Hissène Habré was brought before the courts in Senegal is because in 1990, he fled to Senegal after being deposed by the president who followed him after, Idriss Déby. Between 1990 and the end of that decade, Hissène Habré lived in what one would consider relative luxury until, and it wasn't African leaders that called for his prosecution, until victims of the crimes committed in Chad, I'm not saying by him, I'm not a judge. Crimes committed in Chad called and agitated for the prosecution of someone, anyone, for the crimes committed between 1980 and 1989. It was the voice of those victims represented in the courts, one by the prosecution, but more significantly by Jacqueline Modena, a victim herself from Chad, who represented victims in that process, agitating for justice. It was the victims who wanted justice. It took now 26 years in order for us to get to the day, 3 days before the judgment. And I will end now, Chair, in terms of should Africa withdraw from the ICC. That decision is not made by African citizens. That decision is made by African leaders. In discussing that and in responding to whether African countries, individual as they are, should withdraw from the ICC, I won't answer that. I'm not an African leader. But African leaders must listen to the African citizens who are agitating for justice.
Well, it looks like I'm going to have a difficult day. Now, Judge, we went through your notes. I hope we... There is something called copyright. So we're at a point where we are having a little discussion, and I'm asking the question, just to kick off the discussion, as to whether we Africans should have withdrawn from the court yesterday. And
Professor, please, Judge Afago was requesting. I've indeed explained to him that thanks to you, you went through the text.
Copyright.
But he was requesting just 2 minutes from you, just to conclude.
Very well.
The presentation, and then we continue. You don't need that, you can use that mic.
I think as attention-seeking behavior goes, that was a bit extreme. But thank you very much for your generosity and kindness. There was a large group of Sangomas in the basement. What I'm going to do now, and I have a lot of sympathy for the moderator, because as soon as he came here, he would have seen that these were notes and not a speech. So if he made sense of it, he must have done very well indeed. And let me pick up from saying this, that there is indeed a tension between the quest for peace and the quest for justice. And it's very important that we don't deny that there is such a tension. Because if we don't recognize that, then we will not be able to find the balance, and it's a delicate balance, to be struck when we're seeking to serve our African peoples. Now, the work of the ICC has been controversial, and we're going to talk about that. but it was a court that was called for by the world, but it was called for with certain expectations. The expectation that it would not be a court that would cause disruption. It would be a court that would ensure accountability, but it would be sensitive to context. And I think I remember it was Kofi Annan, the Secretary General of the UN, who, when he was in South Africa and this question was discussed, he made the remark that the ICC couldn't possibly have interfered with the transition in South Africa because it wasn't designed to thwart the aspirations of the African people, that it was a court designed to make sure that the powerful do not abuse their office by committing crimes against their subjects. But when you come to some contexts like Uganda, where it isn't the powerful, it isn't the government that is committing these crimes, but it is insurgents, it's people who are in contestations, often with the state, but sometimes with each other. It means that we can contemplate other options, other ways of ensuring there is accountability, and particularly justice done as close as possible to the scene of the violations. Now, for me, one of the most significant doubters, or people who've been questioning some of the direction of international justice more recently, is a very senior judge, indeed a Supreme Court judge in her country, and also a prosecutor at the highest level, who also served as a human rights commissioner. And this is what she said. I'll give you her name at the end. She said, recent events, whether the Security Council referrals, the difficulty that the court faces in Africa, or its balancing act in the Colombia case, recent events appear to challenge the assumption underlying the international justice enterprise that holding military and political leaders accountable for war crimes would actually contribute to peace by deterring such conduct in the future and by encouraging national reconciliation. She's saying that the evidence is that international justice, and I'm not just talking about the ICC, does not necessarily deter, does not necessarily contribute to national reconciliation, does not always contribute to peace. If you look at the combination of international justice and international intervention in Libya, you will see that it's not in a better place today than it was before. And I'll digress, and President Mbeki will remember this. Before these events, there was a lot of effort to say, take a different approach to Libya. Don't rush into it. It's going to be very difficult. And these were people living on the borders of Libya saying, we know our neighborhood. This is going to end very badly. But sufficient notice wasn't taken of those concerns. And a lot of people are paying for that. It is important, therefore, and I should disclose this is Miss Louise, I should say, Abo, who was the prosecutor of the Yugoslavia court and also worked for the United Nations as a Commissioner for Human Rights, and is now and has been with the International Crisis Group. So what are the alternatives? In a sense, we're not talking about alternatives. We are talking about a holistic approach to dealing with the problems of Africa. What people in northern Uganda were calling for was not that there should be no justice, but that it was better for justice to be done in Uganda, and it was better for justice to be done in a way that was true to the community that suffered the most. It was important for justice to be done in a way that enabled the peace process to go forward and the war to end. And I was one of those who traveled to go and see Joseph Kony, to explain to him that the world had changed around him. There was an arrest warrant against him, but that I trusted that the Rome Statute and the court was a court of last resort, and it was a court that would yield to the prerogative of the government of Uganda and would respect the choice to have justice and accountability within the country. He cited to me, and those of us who were around, the case of Charles Taylor. He cited Thomas Lubanga and said the reason why these people were taken off to The Hague is because they were weak, and they were perceived to be weak. The ICC is coming after me because they perceive me to be weak. What assurance do I have that if I sign this peace agreement, as you're advising me, and come to Uganda, the same thing will not happen to me? We couldn't give him that assurance because it was not in our hands. It was in the hands of the judges. It was in the hands of the prosecutor of the court. So I have no doubt that the reason we were not able to complete that chapter of conflict in northern Uganda was this big intrusion, this cloud that was hanging over the talks. The question of African alternatives, and I'll move towards a conclusion with that. What is it that Africa brings to this discussion of justice, to this discussion of accountability and peace? First of all, in dealing with conflict, in seeking to address the matters of accountability, the context is very important. Almost all of our conflicts, I don't know of a conflict in Africa that is not political. That isn't a contestation to be recognized within your own country, that isn't about marginalization. Some of it is about resources, but essentially it's about which group controls resources. So essentially it's political. And the danger with international justice is that it depoliticizes this context. And it can often leave the impression that it's a bunch of criminals running around. So as difficult as the consequences of this conflict are, the manifestations of crimes are, we must start by seeking durable solutions for those conflicts. And it's important to do so with the full participation of the people who are affected by the conflict. Nowadays, the issue of victims is being put forward. When I was having my arguments with the court and with Mr. Ocampo about his investigations and the potential danger, he said, well, the Acholi victims may not want this, but there are victims next door who speak a different language. They will want justice. So he went to those victims, and they said, no. We want now to secure the end of the conflict, and then we will talk about matters of justice. I'm not saying that in every situation that is a sequence that is appropriate. In some situations, clearly, a powerful abuser using the state, there may be no reason to hold back because you're simply turning off the power of the state. But where you have a situation that's going on and on and on, and war can't end the misery of the people, then we have to look at other alternatives. And I actually believe that the Rome Statute has the architecture to be more subtle than it has been in the years that it's been operational. It has the principles to yield to the prerogative of the state. It has the principles to refrain from action if it's not in the interests of justice. There is such a principle in the statute. But what has happened is that the jurisprudence privileges prosecution, privileges going ahead with cases. So it is our responsibility as Africans to provide the reasoning, to provide the principles which would guide the development of international criminal law, would guide the decisions of the court so that they are nuanced, so that they are adaptable and can reflect the needs of all victims, not just the ones who've suffered direct harm, but also the ones who didn't plant flowers, the ones who lost their children as they were waiting for war and the crimes to end. Those victims count as well. And often they're the majority of the victims. The other thing that we can bring to this whole discussion of international justice, and this goes beyond the ICC, is the African idea of reconciliation. It's become a controversial term, perhaps because it has been abused to mean sweeping the past behind us and not confronting it. But reconciliation, I mean, a clear-eyed view at why things happened, why violations happened, but being determined to go beyond the status of a victim, but to be citizens together, citizens that have been rehabilitated after their experiences as perpetrators or as victims, so that you don't have a country of victims, but you have a country of citizens with different histories, but a common future. We need to reduce this into principles that are justiciable, that can be understood by lawyers and judges. How can a system of law reflect those restorative values and principles that we find in our African culture? In northern Uganda, the communities insisted upon this and say we have a justice system that doesn't dwell on the past, that brings some form of end to the past, a ritual end to the past, to say we accept that all of these things happened to us. There's no way of denying that. But we want to bring healing, we want to move on together. I think the best criminal justice systems should lead to this outcome of restoring what was broken by the crimes. Because if we adopt a system that is exclusively retributive, so that the chief aim of the criminal justice system is to punish, to throw away the key after locking somebody up, it will fail to make the contribution to building a better society. Think about this for a moment. We are facing the challenge of what is called violent extremism now across the Sahel, from Boko Haram to Al-Shabaab, to Al-Qaeda of the Maghreb. We're not going to indict our way through this issue. We're going to have to understand better the context that produces this extremism. What is the variant? What is the abuse of faith that produces this? Who are the people who get radicalized? Are they going to feel daunted by an indictment when they're willing to blow themselves up? I suspect not. So we have to be humble about the limitations of criminal justice. And we have to insist that, and to keep looking for the alternatives that will help us globally through the international criminal justice system, but also within our own countries, to find ways of dealing with the past that consolidates the prospects of a future. Now, I really will come to an end now. So what should we do? How do we come to a happy balance where we have an international criminal court that is a court of last resort, that manages its cases in a fair manner, so you don't have people endlessly detained without release, something that couldn't happen in a domestic court, waiting for years for trials. We don't have discrepancies in sentencing and so forth. How can we contribute to criminal court, which is a court that will respect the rights of states, of societies, to organize their own accountability mechanisms and criminal justice? I think we should start with analysis. We can't purport tonight to have all of the answers. The African Union has started by calling for analysis, by calling for brainstorming, by calling for the development of policy. But those of us who are outside the African Union should contribute to that, including academia, so that our jurisprudence can be informed by legal scholarship. And we can't leave it to lawyers and judges alone, because these conflicts, these tensions, these situations that give rise to crimes are intensely political. And their solutions are not only legal. So do trust the judges, but trust them with the letter of the law. What are the principles that should inform their thinking? Because they need to be looking outside of the legal texts for these principles. And these principles should come from the analysis we undertake. The think tanks, African think tanks, should make this contribution in partnership with our ivory towers. We should also mobilize opinion in a manner that reflects our priorities as well, that says that absolutely we must have accountability, but absolutely the conflicts of this continent should come to an end so that we can build a more prosperous future. I understand from the facilitator that he read my last paragraph, which is the conclusion. But out of Africa, new and good things must come. And out of Africa should come a rethinking of international criminal law, moving it away from retribution, infusing it with more restorative elements. Out of Africa must come new ways of ending conflicts, new understandings of accountability, which means that we continue to work with abusers until they're changed and until they reinvest in society. Out of Africa must come the idea that victims become citizens, become leaders, and become equal partners in shaping their own future. And we must be determined to achieve this, whether in or out of membership of the International Criminal Court. We must be clear for ourselves what our societies need. Thank you very much.
You know, when Bob Marley says, don't worry about a thing, everything is going to be all right, he means this. Thank you very much, Judge Afago. Thank you very much. There is somebody who's going to do a special thanks to you. But I just want to give an indication that the special envoys that came to me, I see lots of ambassadors in front of me, that says we're going to skip dinner. and we're going to have the discussions for the next hour. because I think that's why people are here. It's intellectual thirst rather than food hunger. So Prof. Juma, you have it from me. You've got an hour. Let's proceed. Thank you very much.
I couldn't have done justice to Judge Afako's address. Thank you very much. Now, I think time has now come when we could ask a few questions. But first, let's give the panelists 4 minutes just to say a few words, and then we can invite questions. Mr. President?
No, Professor Juma, if I may, I want to start off from where you left off, when he came back. You had asked a question about whether we should stay in the ICC, Africa should stay in the ICC or not. That's the question that was posed. But first of all, Lepani, let me say thanks a lot for, yes, you can see he's back in full force. Thanks a lot. That's very good. You know, you'd remember the time when just before the end of the conflict in Liberia, the Americans had made a public commitment to send peacekeepers to Liberia. And they were taking time about it. So I spoke to President Bush. So I said to him, "No, President, you people have made a commitment to send these peacekeepers to Liberia. When are you going to do it? Because we need to end this conflict." So he says, "I'm waiting for you." So I say, "But why?" He says, "Because you've made a commitment that you are going to persuade Charles Taylor to leave Liberia." I said, "Well, that's true. So how do these things come together?" He said, "You see, if we deploy Americans now, they'll be obliged to arrest Charles Taylor. It's better that you take him away so that by the time we deploy, he's not there. So there's nobody to arrest." And he said, "You see, because if we arrest Charles Taylor, there will not be peace in Liberia. So please take him away and we'll deploy." So we said, "Okay," which is what we did. And that's it, a practical example of this connection between peace and justice. And President Bush understood it very well, that if you went for the justice thing, you are going to sacrifice peace in Liberia. And so we had to make a choice. We had faced the same challenge when we were dealing with the issue of Darfur. This was 2009. We spent many months in Darfur talking to everybody, including the people in the displaced people's camps, and even going to Chad to talk to the refugees and so on. Really, to the thing that Otilia was saying, to get to understand what even the victims of the conflict in Darfur, what do they say, what do they think? And many of the people in the displaced camps would say to us, President Bashir must go to The Hague. Others would say no. long discussion. Then when you talk to the leadership among the Darfurians and the rest of Sudan, they would say, no, don't. And when we talked to the leadership in South Sudan before secession, they would say, no, you can't, because if you take President Bashir away, for instance, in the South, they would say, if you do that, it will not be possible for us to maintain the peace agreement that we've signed. We want him to, as this in place, President Bashir, so that indeed then we can complete this peace process, including referendum, which led to the secession of the South. In Darfur, they would say the same thing, that in order to ensure that this conflict ends, and therefore the manage the soldiers and then everybody else who's causing the conflict, you need this man. If you take him away now, you won't be able to control this process. I'm saying again, here's a practical example of this. The former heads of state on the continent have got this organization called the Africa Forum. They've written to the prosecutor of the ICC concerning President Gbagbo in Cote d'Ivoire. And they've said to the prosecutor, you see, the idea is that, as far as we can see it, sooner or later, Cote d'Ivoire is going to go back into a civil war. And we're very, very concerned that thousands and thousands of people are going to die. And yet, a major player in terms of avoiding that civil war and bringing peace, a lasting peace and reconciliation to Cote d'Ivoire would be President Gbagbo. You might win some legal battle and say, no, we've managed to convict him, he's serving I don't know how many Sundays, if that's what happens. But the price for the Ivorians is going to be very high. So what do you do? Now, to answer your question, Professor Chuma, I think whether Africa should stay or not in the ICC, I would take the position of the African Union on this matter. What the African Union has said is that we must seriously consider this matter in the manner that Judge Afako was suggesting. We've set up a committee of foreign ministers to say, look, you people look at this thing and come and make recommendations to us as to how to answer that question. And I think that's the correct way. And I think that's the correct way to come at it. Taking into account what Judge Afako said, that we must apply our minds to it, look at the thing, and say, from our own experience, and then what should go into a decision? We stay or we don't stay? Last point about this, and come back to Sudan. You know, they've got in Sudan something called blood money. Dear, I kill Otilia's brother. I won't do it, ma. I kill her brother. So she rallies her family, says that Mbeki family has done us great harm. Let's attack them. So they come and kill us, and we say, we must revenge. To avoid that, they've got a traditional practice in Sudan, this thing that's called dia. It's called blood money. So I'll kill her brother. Please don't. And then the family will come. Her family will say, you've done harm to us. It's going to cost you whatever. So many cattle or camels or something. If you pay us that, we'll forgive your sin. It's in the judicial system of Sudan. Formal, normal court, like a normal South African court, will find me guilty of murder, but will ask the family of the deceased, what do we do with this man? And the reason they do it is to say, You've got to come to these things. These are people who live in the same village. In the end, you've got to come to this process of reconciliation. And this business of all you need to do is address the justice matter. A brother has been killed, therefore lock this one up and hang him. Perpetuates the conflict among the people. In the end, we want this killing to stop, and we want to live in peace with one another. I think that's a very interesting practice. I'm saying it's practiced up to this day, to reduce the levels of conflict in society. And therefore, an obvious automatic resort, as Judge Afago has been saying, to punishment as though here you have a criminal and here you've got a victim of the crime, punish a criminal in situations of this kind of conflict. It is not a criminal conflict, it's a political conflict. It may very well be that you might need solutions such as might hopefully come from this Committee of Foreign Ministers of the African Union when they make a recommendation as to whether Africa stays or leaves. Thanks.
I think now we have Judge Afako. Do you want to weigh into the discussion for 3 minutes or to answer that question? Or you want to pass? The mic for Judge Afako. Okay, he will come when the mic is. Now, this is the opportunity to ask questions to the panelists. Now, this is not a chance to give a speech. We will invite you, and Marx as a book is recording, we will invite you to make a speech. This is an opportunity to ask one question to the panelists. And I would like to take 5 questions all across the room and give the panelists a chance to answer. And when we have more time, I'll take another round of 5 questions. I do not know whether there are roving microphones around. Max, do you know? Good. There are roving microphones. 5 questions. I start from this side. The gentleman at the back. Yes.
Thank you very much for the opportunity to all the leaders in the front. I want to concur with the question of whether African leaders actually listen to their own people in making the decision. And just to make it quickly, as Africa as a continent, it seems that the entire work of the ICC, probably 75% of it is focused on the pursuit of African leadership. But when you look at other conflicts that happens outside of the African continent, like what we have seen in Iraq, where we do know very well that the very masters had clearly had a political agenda than what they actually paraded, there is nothing absolutely that the ICC pursues from the cases of Bush, what we have seen in Iraq. But where it concerns the issues of African leaders, that is where the ICC is most concerned and look like it's the ICC for Africa, not for the world. Thank you.
Thank you. Yes, the gentleman in the middle. Yes.
Thank you, Mr. Speaker. In balancing justice and peace within Africa, how relevant are the views of non-African states?
how relevant are the views of the African states? How relevant are the views of non-African states? Thank you. In the middle? Yes, the gentleman at the back.
Thank you very much. All of the UN bodies or maybe associations, whether it's UNICEF, it's ICC, WHO, whatsoever, they are all in the north, on the western side of the world. So is there a possibility that maybe the ICC can be devolved in its sitting and maybe one day sit in Africa with a full African bench and mostly black judges to give a reflection of universal justice?
Yes.
Thank you. Protocols observed. My question is that how do we balance if we decide as AU to move away from ICC? How are we going to be able to judge countries that abuse their statutory obligation in AU? Because for the mere fact that we decide as the continent to leave ICC, how are we able to make sure that at AU we establish our own international criminal court? So I just want to hear the view from the panelists. How are we going to be able to balance human rights versus our legal obligation? Thank you.
Now, it has all been, gentlemen, there are students on this side. Give her a chance, please. Right there. Yes.
Okay. My question is, I'm told every day that the future is in my hands and that I'm a leader. Can anyone hear me? Okay, and that I'm the future of tomorrow. I'm aware of the challenges that we face every day, and that I believe that the futures of tomorrow have so much to conquer. Yet I believe that peace and justice can be prevailed. Yet how do you advise those who do not have the faith that it can be prevailed?
Thank you. There she is. Thank you.
I just have a question about the mutual exclusivity between peace and justice. It seems that peace and justice seem to be mutually exclusive concepts. Is it not that justice could be a precursor to peace? And I'm going to just quickly move away from the ICC and just use South Africa as an example. A lot of people believe that the revolution in SA was a suspended revolution, and it has yet to come because justice was compromised in the place of peace. So my question is, if we are going to put peace first as the forerunner, how do we balance getting justice but not compromising peace? And how do we not compromise justice in our quest for getting peace? Thank you.
There's a gentleman at the back. Yes.
Good evening.
Go
Okay,
ahead,
my
go
question,
ahead.
my question is based on most of the things that were said earlier. We spoke about the ICC getting involved in African conflicts, meaning that they were getting involved in the aftermaths. So my question is there a possibility that they are involved also in provocation of those conflicts?
Thank you. Now, this group. Here? No hands? No hands? In front here? Right here? No, here, please. Yes, go ahead.
Thank you very much. Dumale Mohlaudi from SABC, SABC News. My question just comes on the issue of capacitating Africa. I know that there is a court for Africa's own conflicts that has been set up, but I just want to know, does this court have the capacity to litigate and to hear some of the issues that, as you've discussed, that the ICC has been, entrusted to deal with, and without capacity and ensuring that there is justice being seen to be done, will this institution be a credible alternative to the ICC? Thank you.
Thank you. And here? Yes.
Thank you very much. Let me ask a layman's question. Is a world where peace, justice, and security exist real or imaginary? Full stop.
Thank you. Now, those are very weighty questions. I think it would only be fair to give the panelists a chance to respond before we take another round of questions. Who do we start with?
I can start.
Very well. Otilia.
Ladies first. We've only had one question from a woman. And thank you very much for your intervention representing students and having the courage to stand up and pose that question. That is very commendable. We had a second intervention as well. In that, I'm going to try to respond to as many of these questions as possible. There are 9, Chair, out of 5. On the first question that you posed around the charges against those who were complicit in crimes committed in Iraq, it touches to one of the key issues and challenges of international justice, which is what happens when crimes are committed in a country that is not a signatory to the Rome Statute, which Iraq is not. And in that circumstance, which has happened in Sudan in 2005, in line with Resolution 1593 of the UN Security Council, and then later in Libya in 2011, is that it's a referral by the UN Security Council. It was a compromise that was reached in 1998 in terms of what body outside of the internal structures of the ICC, as well as states parties, that would do that referral. The challenge there, and this is a challenge that has already been presented by Judge Barney Afako, is where the UN Security Council does not act for whatever reason, which they have not done in Iraq, which they have not done in Syria, what happens then? So the challenge of the ICC in respect of situations that are non-states parties is actually a challenge inherent in the UN system. It is a challenge of political imbalance, not so much judicial imbalance. Now, speaking very specifically then to the question that was posed somewhere there around sessions of the ICC outside of The Hague, the Rome Statute provides for such sessions. However, it provides at the moment, what it doesn't provide for is the headquarters. The headquarters was chosen, however ironically, to be The Hague. I say ironically because when the idea of a permanent international criminal court was first envisaged in 1917, not 1994, it was The Hague, it was the Netherlands that refused to extradite the then King of Germany, Kaiser William, for him to face prosecution. And so now the ICC is headquartered there. But it can sit elsewhere, and it does have judges that are contributed from member states. And then moving to something that was touched on by various interventions, and as I end, so that I can leave the harder questions to the Honorable former President and Judge Afako, which is the issue of peace and justice. Now, how we have been speaking about both peace and justice has been through the lens of political peace, and in many ways of political justice as well. Now, the problem in that is that, unfortunately, when we speak about peace, and President Mbeki spoke about people speaking about, if al-Bashir leaves, what then? is we're speaking about individualized peace that is dependent on a person. What if al-Bashir leaves? Will there be no peace in Sudan? Does the peace of the people in Sudan depend on a person? And is that by way of design of our political systems that we rely primarily on individuals in order for them to be the ones who inform our peace? Or is that really because the rest of us have nothing to say of that? Because if peace is dependent on one person, if peace is dependent on one person signing a peace agreement, that person can hold peace at ransom. At the same time, and this is probably one of the only things that political peace and political justice have in common, is that political justice speaks to individual criminal responsibility of a named accused. So the people that we know, when we speak about the ICC targeting Africa, we are speaking about the ICC indicting certain Africans amongst us. And the people that we know, the named people that we know, are the indictees. We don't know anyone else. If I were to put it to the audience, who they know in respect of what is currently being prosecuted at the International Criminal Court, my guess is many people will say al-Bashir. We've mentioned his name more than we should. Second guess would be the mention of Laurent Gbagbo, people indicted by the ICC, not the people affected by the crimes for which said people are indicted. And I am not here to make judgment as to the guilt of al-Bashir. I repeat, I'm not a judge. And so with every accused of any criminal court, the presumption of innocence until proven guilty rests. And if we treat political peace and political justice on the basis of an assumption of guilty until proven innocent, we run the risk of Joseph Kony saying, I am not weak.
On now? Yeah. Yes. I want to remain optimistic that a world where there is both peace and justice is possible, and it's what we should all work for. It's not easy. There is complexity involved in how to strike the right balance. And I think the points that we're making today is about that balancing exercise. And we're expressing dissatisfaction with the way that it has been approached, that it has been mismanaged in certain situations. So yes to peace, yes to justice, yes to aspiring for those, and certainly yes to making the compromises, because you can't run away from that. You're going to need to make compromises as to how many people you can prosecute, what your resources are, and what it takes to bring conflicts to an end. But I do say that yes, individuals are important for bringing conflicts to an end, because individuals fight wars and have stakes in the outcome of both peace and conflict. About the idea of bringing or Africanizing justice and bringing it to the continent. You see, if the architecture is the same, we have a Gambian prosecutor. We have a lot of African judges at the ICC. There's nothing personal against them. It is the system. It's the priorities that you have to infuse into the system. So bringing an African court in Addis Ababa or Arusha with the same approach will still be problematic. You still have to confront the question of how do we manage a transition, as here you had in South Africa? How do you manage to come out of conflict when the people perpetrating and pushing these conflicts are afraid of justice? Or when these people have political constituencies? Because international criminal justice is about symbolism. The reason these people are named is not that they pulled the trigger, but it's because they're at the top of an organization. So it's not the same as the thief you catch round the corner, red-handed. That stops there. The buck stops with them and starts and stops with the thief. But in case of the ICC, the buck starts somewhere else and it stops with this person. For every person indicted at the ICC, you could choose 5 others on the same principle, on the same evidence. So it is true to say that the indictments are about intervening at the top. And once you do that, you've inserted yourself into the politics of it. And that's why it attracts the reaction that it attracts. Now, what was the other significant question that you left out? Okay, very well, thank you.
You would judge, you would come back and affiliate to the one I live at.
Why is my microphone on?
I think everybody knows that there is a court, an African court on human and people's rights. It's been in existence for some time. There was a decision taken some time back that there should be an African Court of Justice, which would then deal with all of these cases, human rights, violations, war crimes, genocide, that are in the Rome Statutes. As I understand it, the protocol for that court has been completed and is in the process of ratifications by the various countries. So indeed, there is already a decision on the continent to set up an African court which would try the sorts of cases that go to the ICC. And as I say that, this is what I've been told. And so once that protocol has been ratified by the requisite number of countries, presumably then the court will be established on the continent, so that in a sense, our second port of call after the national one would be the African one. In that context, I must say, I think the point we need to make this point, that there's nobody who has said on the continent, we do not want the ICC in principle. Nobody. But people have said there are certain things that need to change in the manner in which the ICC operates, and have made proposals about that. You see, you have this example that stands out. I'll come back to Otilia to this thing you were saying about individuals. When the African Union says to Security Council, you people who referred the case of Darfur and therefore President Bashir to the ICC, can you please intervene and defer serving of this warrant for a year? Not to withdraw the warrant, not to withdraw the charges, but just defer. Now, the thing about individuals, let me talk about President Bashir. You see, when you intervene like as a facilitator, mediator, in a situation like this, it's not as you want the situation to be. It is as it is. So you will find, you'll find quite regularly in many of the African countries that these people who occupy the position of president are actually very, very powerful. In both positive and negative ways. I think the South Africans know what I'm talking about. So in a practical situation, when the South Sudanese who've been fighting the North for 40 years, when they say to us, please don't touch President Bashir, it's because they know precisely the manner in which power is exercised in society. And when they say that, and they say, please keep this man because we want peace, is because they know the practicalities of the exercise of power in Sudan. Didn't come from us. We didn't say, don't take Bashir to the Hague. It comes from these people. Now, it might be the point that was made, that might be read as an unjust, incorrect, a compromise, a peace which compromises justice, which is a question that was posed: how do you not compromise justice for peace? I'd like to put the question the other way around. How do you not compromise peace for justice? It's the same question. You need both. You can't say, you see, let us stay with this example of Sudan. The South Sudanese, I'm saying after 40 years of war, the South Sudanese, at last, 2005, an agreement is reached that 6 years after that, which was 2011, they would have a referendum to decide whether they want to be an independent people or they want to stay in Sudan, an independent country. So they win this right. Now, and here I come with a warrant from the ICC. And I say, I'm going to arrest this man and take him. Now, the Sudanese are faced with a problem. The South Sudanese. Do we agree that this man goes? What is the price we will pay? The price we will pay is that this war will continue, during which already from 1983 to 2005, over 2 million people died. Now, do we say we don't want to compromise justice for peace, and because of justice, take this man away, and the cost is another 1 million people dead? You can't do it like that. Both of these issues are important. The justice is important. The peace is important. This was the consideration here as we negotiated the transition. That we needed to end apartheid and end the conflict which was claiming the lives of too many of our people. And it's our people who are dying. It's the oppressed who are dying. We said, look, as leaders, you can't allow this. We've got to find a way of ending this killing and ending apartheid. How do you do both? And that's how the TRC came into being. You know, there was already a convention, an international convention, saying apartheid is a crime against humanity. The legal basis in international law existed for us to say, lock up, declare. But then we had to sit and say, okay, sure, if we had the means, maybe we might, but what's the price that we pay? And said, let's do it with the TRC way. Let's end this apartheid rule. You can't ignore the issue of justice, but how do you deal with the issue of justice? There's no prescription. What's the context, as Judge Afako was saying? What's the context of all of this? So, you don't need to compromise justice or peace, but the manner in which you approach any of these issues, including the question of peace. In the South African case, maybe we compromise democracy in favor of peace. When we said, let there be a government of national unity, the ANC was in the majority. The ANC could have governed on its own. But we said, no, in the interest of peace, let's compromise that democracy. These are the actual practical choices, not theoretical things. So if indeed there will be an African court, it doesn't mean that there's going to be any movement out of the ICC, But the ICC must continue to act as a court of last resort, as Judge Afako was saying. And indeed, the ICC needs to listen to the proposal. The state parties to the Rome Statute need to listen to what the continent is saying about its concerns. Because the thing about saying, look, don't hold your warrant, don't tear it up, but that's defer serving it for a year. They must understand that the reason for that is not irrational. It's not because the African heads of state are saying that there must be impunity. It's not because they are protecting a fellow head of state, but they are protecting an advance to peace, which is going to save hundreds and thousands of African lives. And you can't say, just by looking up Barney, this trumps 500,000 people dead. You can't say that if you're a leader of a people. That this principle, I'm very glad that I've succeeded, I've locked him up, I've won a case. At what price? Hundreds of thousands of people dead. And you think you're a leader? You're not.
According to the time that Max gave me, we still have a few minutes for maybe 3 questions. 3 questions. 3 questions. Let's start with the students. Leaders of tomorrow, you know. At the back, please, at the back. Yes, at the back, yes.
My question is, should the ICC leave Africa, what happens to Africa then? Should the ICC leave Africa, what will happen to Africa then?
Okay, in the middle? There's nobody in the middle? The microphone, please. Yes, there's a gentleman at the back. In the middle?
Can you please open up the floor to the students?
Yes,
Thank you
at the
very
back.
much.
At the back. Yes. That gentleman at the back, yes. Yes.
No, thanks very much. Former President, I salute you. But I think it's time that we need to also take stock. The Government of National Unity, I'm impressed by one thing you've mentioned. It had a lifespan. But the roadmaps that we see, it looks like some of the leaders, because they know they have the capacity to cause havoc, they really put that on front of the negotiators and the mediators to say, either you let me go or I cause havoc. I think that is the question that I'm asking you as former president, and I know you have that capacity. Only you should answer it. Thank you.
Yeah, the last question.
Can we please open up the floor to the students?
Yes.
I'm going back to history. We were never treated as human beings. We were treated as subhuman beings. Why did we sign up without thinking about that and putting our culture and our norms and values to say this is how we would want to be treated when we sign up, rather than it being an afterthought to say, oh, we didn't think about how they would treat about us. We should have thought about it before we signed up.
Thank you. I'll ask, in the interest of time, I'll ask the panelists to respond. And there will be more time for discussion, I understand, after we finish.
So
Informal discussions. Informal discussions after we finish. Now, can I ask the panelists to respond? I'll ask Otilia, and then I'll ask Jaja Fako, and then President Mbeki will finish.
There was one question that was posed in the last session, which was around actually operationalizing the African court. So beyond having a theoretical court or a court on paper, is it actually a feasible option, which was posed by you from the SABC? And this was one of the key challenges in terms of developing the protocol that is now pending ratification. No country has ratified it yet since it was adopted in 2014 in Equatorial Guinea. And one of the key issues that was raised in the preliminary process, not by coincidence, but by South Africa, was the funding of the African court, right? And one of the problems is the costly nature of international criminal justice. And trying to find the right amount of financial resources in order to be able to actually mete out that justice. So now what is actually happening, and the reason why there haven't been ratifications, is that the Office of the Legal Counsel at the African Union is basically consulting in terms of how do we properly operationalize the African court so that we don't have a lame duck, as it were. Now, one of the key issues with